My roommate's girlfriend has been living in our apartment rent-free for 3 months, and now they're saying I'm the one who has to leave. I've lived with Brock for over a year, and we've always split everything evenly, 50-50. Things were fine until his girlfriend, Sienna, started staying over about 3 months ago. At first, it seemed temporary. Then she just never left. She's been here every single night since then. Our utility bills increased fast. The electric bill jumped from $80 to $140. There's more cooking, longer showers, and the air conditioning is running all day because Sienna works from home. Even with all of that, Brock and I are still splitting everything evenly. That means I'm paying half the cost while supporting 3 people. I started to feel like a guest in my own home. I'd hinted about it before, but Brock always brushed it off. Eventually, I hit my limit. I could barely afford rent as it was. I decided I needed to have a real conversation. I gathered our recent utility bills and highlighted the increases. I waited until Sienna left for a yoga class, then sat Brock down at the kitchen table and explained everything. I told him Sienna had been living here non-stop for 3 months, the bills had gone up significantly, and I was covering costs for a third person. Brock actually looked uncomfortable. He admitted I was right and said it wasn't fair. He agreed she either needed to contribute financially or spend more time at her own place. I stayed calm and told him that was all I wanted: fairness. Brock said he understood and promised to talk to her that weekend. Over the next few days, Sienna wasn't around as much. She stayed over only 2 or 3 nights instead of every night. I felt relieved, like the situation was finally improving. Brock even texted me midweek saying he and Sienna had talked and were working on a solution. He paid his share of utilities on time and even sent an extra $20. For the first time in weeks, things felt normal. That calm lasted about a week. The following Thursday, I came home around 6 in the evening and walked into the kitchen to find Brock and Sienna sitting at the table with a third person. He was wearing a business suit with a briefcase and paperwork spread out. Before anyone spoke, I knew something was wrong. Brock introduced him as their attorney, Harrison. His tone was cold and distant. Sienna sat with her arms crossed and wouldn't look at me. I asked what was going on. Harrison spoke formally and said Sienna had lived at the apartment for over 60 days, which made her a legal tenant under state law, even though she wasn't on the lease and didn't pay rent. I argued that she wasn't listed on the lease. Harrison said payment didn't matter, length of stay did. He slid documents across the table, including printed screenshots of my text messages complaining about the situation. He accused me of harassing a legal tenant and creating a hostile living environment. I was shaking. I said I was only asking for fairness, but Harrison said demanding a tenant leave without legal cause qualified as harassment. He then handed me a document with an official seal and told me I had 30 days to vacate voluntarily or face formal eviction. I reminded them I was on the lease and paid rent every month. Harrison said that was why they were offering the voluntary option first. I looked at Brock and told him this was my home. Brock said he was the primary leaseholder and had authority. When I reminded him of our agreement, he said he'd handled it. That night, I didn't sleep. I searched online for roommate eviction laws, but everything focused on landlords and tenants, not roommates forcing someone out. My savings were under $800, and I realized I might be homeless in 30 days. Around 2 in the morning, I found a tenant rights forum. Someone mentioned that most lease changes require all tenants' signatures, not just the primary leaseholder. I saved everything. It was the first hope I'd felt. The next day, I called every legal aid clinic I could find. Most had long wait lists, income restrictions, or didn't handle these cases. One paralegal suggested I find a private attorney. She gave me 3 names. Only one called back. His name was Craig Monahan. The consultation cost $200. I gathered every document I had: lease, bills, bank statements, eviction text messages, and brought them to Craig's office. After reviewing everything, he told me Brock couldn't evict me without my consent or a court order because the lease required signatures from both tenants. I almost cried from relief. Then, he explained the problem. I'd still need to file a legal response to stop Brock from pursuing eviction, and his retainer was $5,000. I couldn't afford it. He said I could try filing myself, but warned that mistakes could cost me the case. A few days later, I came home and discovered the Wi-Fi password had been changed. Brock told me I wasn't entitled to amenities anymore. I needed internet to file legal paperwork, so I went to the public library. A librarian helped me submit everything online. The court emailed back saying a hearing would be scheduled within 30 days. The next morning at work, I was called into my supervisor's office with HR present. They told me a complaint had been filed accusing me of stalking and harassment. They showed screenshots of threatening text messages sent from my phone number, messages I never sent. I was terminated immediately. Security escorted me out while coworkers watched. Sitting in my car afterward, it clicked. Sienna must have fabricated the messages. They weren't just evicting me, they were destroying my job and reputation. I called my parents for help. Instead of support, they told me Brock had already spoken to them. He portrayed himself as reasonable and me as unstable. They believed the fake messages. They refused to help financially and told me to apologize. Within a week, I was filing for unemployment, buying cheap food on credit, and selling my belongings. A former coworker connected me with a temp agency. I took whatever work I could: warehouses, overnight retail, data entry. The pay was low, but it was something. Brock and Sienna openly discussed turning my room into an office. 2 weeks later, I was served with a restraining order petition. It accused me of violent threats and listed the same fabricated messages as evidence. A court hearing was scheduled for 1 week later. A judge will decide whether to issue a temporary restraining order. I read the paperwork 3 times, trying to fully understand what it meant. If Brock gets this order approved, I'll be legally barred from my own apartment. I won't be allowed to return home. I also won't be able to fight the eviction because I'll be prohibited from being on the property. That's the real strategy here. Create an emergency that removes me before the eviction hearing, where I might actually have a chance to defend myself. I'm standing in the hallway holding the documents, and I can hear Brock and Sienna laughing inside the apartment. My credit card debt is now over $8,000. I'm working temporary jobs that barely cover food. I have no support from my family and no attorney representing me. In 1 week, a judge could legally keep me out of my own home. I read through the restraining order paperwork again, and something about the timing finally stands out. The eviction hearing is scheduled for 3 weeks from now. If Brock gets the restraining order approved next week, I won't be allowed within 500 feet of the apartment. That would prevent me from collecting documents, meeting with a lawyer, or even appearing to contest the eviction. This isn't about intimidation. It's about shutting me out before I can defend myself in court. I fold the papers and put them in my pocket. My credit card statement shows a balance of $8,247. The temp agency paid me $96 yesterday for an 8-hour warehouse shift. The numbers don't add up anymore. I walk to my car because I can't go back inside the apartment right now. Sitting in the driver's seat, I pull up Craig's office number and call. His secretary says Craig has 15 minutes available at 9 the next morning. I take it immediately. The next day, I'm outside Craig's office at 8:45 a.m., waiting. My hands won't stop shaking. When he calls me in, I sit across from his desk and explain everything that's happened since our last meeting. I tell him about losing my job because of fake screenshots, my parents cutting me off after believing Brock's story, and the restraining order hearing scheduled in 6 days. Craig listens without interrupting. When I finish, I lean forward and tell him I'll pay however I can. Installments, a percentage of future wages, anything. Craig closes the folder and shakes his head. He explains that his malpractice insurance requires the full retainer up front. It's policy, not personal. Then, he gives me advice anyway. He tells me to show up at the restraining order hearing with any evidence that proves the text messages are fabricated, phone records, timelines, anything that contradicts their claims. He reminds me that judges take restraining orders seriously, but they also don't appreciate being misled with false evidence. I thank him and leave, knowing at least what direction to take next. I spend the rest of the day calling my phone carrier. Customer service transfers me to technical support, then to the legal department. I'm told I need to submit a written request, which I do online. 2 days later, I receive an email saying they can provide call and text logs showing dates, times, and phone numbers, but not the content of messages without a subpoena. I call back and explain I need to prove I didn't send certain messages. The representative sounds sympathetic, but says a subpoena is required. When I ask how to get one, she tells me I need a lawyer. I don't have one. I spend another full day on the phone, talking to multiple representatives and supervisors. The answer is always the same. I can prove when I texted Brock, but not what the messages said. I print the log anyway because it's all I have. 3 days before the hearing, I finish an overnight grocery stocking shift at 6 in the morning and drive back to the apartment. I sit in my car instead of going inside. I spread all my documents across the passenger seat and dashboard. The eviction notice, restraining order petition, utility bills, and phone records. I pick up one of the utility bills and stare at it. Something doesn't look right. Then I notice it. The bill is addressed to Sienna, but the address isn't ours. It's on a different street across town. I Google the address. It's an apartment complex called Riverside Gardens. I check more documents mixed in with my papers. There's a credit card statement, also addressed to Sienna at the same Riverside Gardens address. My hands start shaking as I pull up the county property records website and search her name. The records list her registered residence for tax purposes at Riverside Gardens, not our apartment, the place where she supposedly established legal tenancy. Everything starts to come together. I search tenant law websites again, more carefully this time. Every reputable source says the same thing. Tenancy isn't just about staying somewhere for 60 days. It requires establishing that location as your primary residence, where you live, receive mail, and pay bills. If someone maintains and pays for another apartment the entire time, they never establish tenancy at the second location. They're considered a guest. Harrison's entire legal argument was based on a false premise. Sienna never made our apartment her primary residence. She was staying over while keeping her real apartment across town. I spend the rest of the day and night researching primary residence requirements. By noon, I'm still in my car, reading legal resources. I go to the library to print state statutes on tenant rights and residency definitions. By 3 in the morning, I have a full folder of documentation and a clear understanding of what happened. Harrison didn't misunderstand the law. He misrepresented it. The hearing is at 9 a.m. I haven't slept, but I feel more focused than I have in weeks. I put on the only decent shirt I own and drive to the courthouse. The courtroom is small. Brock is already there with a different attorney this time. When the case is called, Brock's attorney presents printed screenshots of the alleged threats. Brock testifies about feeling unsafe. He appears calm and convincing. The judge listens carefully. When it's my turn, I present the utility bill, the credit card statement, and the property records showing Sienna's actual residence. The judge looks up and asks Brock's attorney to explain why Sienna has active accounts at a different address if she's been living with us. The attorney says she was transitioning between residences. I point out that the utility bills show she was actively paying for electricity and gas at the other apartment during the same months she supposedly established tenancy at ours. The judge asks if there's documentation proving our apartment was her primary residence. The attorney admits he doesn't have it. The judge doesn't grant the restraining order, but he doesn't dismiss it either. He continues the hearing for 2 weeks and orders both sides to provide documentation proving where Sienna actually lived. I leave the courthouse feeling hopeful for the first time in weeks. I drive straight to Riverside Gardens. I find the building and see Sienna's name listed on the mailbox. I take photos. I wait nearby and speak to a long-term resident who confirms Sienna lives there and works from home. Over the next 2 days, I return at different times, photograph her car in the garage, and speak to additional neighbors who can, even though he had no license to practice law. He made false statements about Sienna's tenant status. He relied on fabricated evidence to threaten me with illegal removal from my home. Craig explains that this behavior may be criminal. For the first time in weeks, I feel a tightness in my chest that might actually be relief. Craig continues reviewing the documents, shaking his head as he goes. He points out that Harrison gave me a business card identifying himself as a lawyer. He presented paperwork with official-looking seals. He made specific legal claims about tenant law that were completely inaccurate. Craig explains that impersonating an attorney is a serious offense in our state. When combined with fraud, false evidence, and threats of unlawful removal, it creates grounds for potential criminal charges. Craig asks if I still have Harrison's business card. I take it out of my wallet, where I've kept it as an unpleasant reminder. Craig makes a copy immediately. He leans forward and speaks more seriously. He tells me he will take my case under a contingency arrangement, meaning he will be paid from any recovery we obtain. This is no longer just about defending against removal. We are pursuing Brock, Sienna, and Harrison for planning fraud together, attempting illegal eviction, and Harrison's false legal representation. Craig explains that I have solid grounds to sue all three parties. The first step is reporting Harrison to the state bar authority that licenses attorneys. He says they treat fake lawyers very seriously. He also recommends contacting law enforcement, as this situation may go beyond civil court and involve criminal liability. I ask what happens next. Craig outlines the plan: an emergency motion to dismiss the removal case due to fraud, a formal complaint to the state bar with full documentation, a police report regarding the threats and false legal authority, and then a civil lawsuit seeking damages. He estimates potential damages in the tens of thousands, considering lost income, emotional distress, legal costs, and punitive damages based on the severity of their conduct. I struggle to absorb everything. An hour earlier, I was overwhelmed by debt and facing homelessness. Now I have a real attorney who believes me and is ready to act. Craig begins working immediately, pulling up legal forms and asking detailed questions. He needs exact dates and specifics. When Harrison claimed to be Brock's lawyer, what tenant law claims he made, what documents he presented, and what threats he issued. I answer as clearly as I can. Craig types quickly, commenting on how obvious the fraud appears. He prepares a substantial emergency motion to dismiss the removal proceedings, about 15 pages long. It includes all evidence proving Sienna never lived with us as her primary residence: utility bills from her other apartment, neighbor statements, photographs, and account records. Craig also prepares the formal complaint to the state bar, attaching Harrison's business card, the documents he presented, and my sworn statement describing the kitchen meeting. Craig explains that the bar investigates unauthorized practice of law, and if they confirm wrongdoing, Harrison could face criminal charges. Craig files everything electronically while I watch. Each submission feels like taking control again. He prints copies for me and advises me to store them securely and create digital backups. This evidence is critical. 3 days later, I receive a call from an unknown number. A woman introduces herself as a state bar investigator. She says they received my complaint about Harrison and want to speak with me. She explains that Harrison has previously been flagged for practicing law without a license. My complaint and documentation triggered an immediate investigation. I take time off from my temp job and meet her downtown. Her office is simple and filled with filing cabinets. She asks precise questions. Did Harrison explicitly claim to be Brock's attorney, present official-looking documents, make legal claims, and threaten legal action? I confirm all of it. She records the conversation with my consent and explains that impersonating an attorney is a criminal offense, not merely a violation of professional rules. She tells me the case is being referred to the district attorney for possible criminal prosecution. Housing-related fraud is treated especially seriously under state law. She thanks me and says the investigation will continue. She notes I may need to testify if charges move forward, and I agree. 2 days later, Brock calls me while I'm working a warehouse shift. I nearly ignore it, but I answer. His tone is completely different, nervous and pleading. He claims Harrison misunderstood the law and insists he didn't know Sienna never made our apartment her primary residence. He says Harrison told him staying somewhere for 60 days automatically created tenant rights, and he believed it. He keeps asking to work things out. I say very little and let him talk. Brock suggests returning to splitting utilities 3 ways and having Sienna stay at her own place more often. He sounds desperate. He admits Harrison is Sienna's cousin and promised he knew what he was doing. Brock tries to portray himself as misled, but I remember his cold demeanor during the legal ambush. I recall Craig telling me my state allows one-party consent recording. I start recording the call. I calmly ask direct questions. Is Harrison licensed? Brock hesitates, then admits no. Did Sienna keep her Riverside Gardens apartment? He admits yes. Was the removal threat based on Harrison's legal advice? Brock confirms it was. With each answer, Brock undermines his own position. He acknowledges Harrison wasn't licensed and that Sienna maintained another residence. His claim of being deceived collapses. By the end of the call, I have a 20-minute recording documenting key admissions. The next morning, I play the recording for Craig. His reaction is immediate. He says Brock has effectively handed us the case. Craig copies the audio and adds it to the evidence file. He tells me we're meeting with a fraud detective next. We meet the detective, who listens carefully as Craig outlines the situation. I play the recording. The detective accepts copies of all evidence, including utility records, Harrison's materials, and neighbor statements. He explains that fraudulent use of fake legal authority in housing matters is treated seriously. He says the evidence supports a criminal investigation and asks if I'm willing to cooperate fully. I agree. At the continued restraining order hearing, I arrive with Craig. This time I'm prepared. Brock appears with a new attorney. When the case is called, Brock's attorney attempts to withdraw the request, but the judge declines, citing concerns raised by the bar and police investigations. Craig presents our evidence: proof of Sienna's actual residence, Brock's recorded admissions, and documentation of Harrison's impersonation. The judge listens carefully and rejects the restraining order entirely. He criticizes the misuse of court resources and refers the matter to prosecutors. Craig files our civil lawsuit the next day against Brock, Sienna, and Harrison. The complaint details emotional harm, lost wages, legal expenses, and punitive damages, totaling $50,000. The defendants are formally served. Within a week, Brock's attorney sends a settlement offer for $15,000, contingent on my moving out and remaining silent. Craig advises rejecting it. We counter with $50,000, Brock and Sienna moving out, written admissions, and no non-disclosure agreement. Shortly after, the district attorney files criminal charges against Harrison. Soon after that, Sienna is terminated from her job for fabricating evidence. The pressure escalates. A revised settlement offer arrives: $45,000, written admissions, Brock moving out, and only a media restriction. Craig advises acceptance. I agree. The settlement documents confirm everything in writing. I notarize multiple copies and store them securely. I send them to my parents. They apologize and acknowledge the truth. My former employer amends my termination record and provides a neutral reference. 3 months later, I'm still in my apartment. Brock has moved out, my debt is reduced, my record is clean. I survived a coordinated attempt to remove me through fraud, and I fought back successfully. If you want, I can. Optimize this for AI voiceover. Split it into multiple audio segments. Create YouTube titles, descriptions. Continue paraphrasing the next section. Just tell me the next step.